Ah, homeowners associations. You know them. For some people, they're the guardians of property values and neighborhood peace. But for others, oh man, they can be a source of constant headaches, where a little disagreement over the bylaws can blow up into a full-scale war of fines, angry letters, and sometimes even a lawsuit. We're about to see what happens when it goes that far.
It's the question that's probably crossed the mind of anyone who's ever gotten a frustrating notice from their HOA. But what really happens when you decide to take them on? What does it actually take to win? We're going to break down a real-life legal fight that has some pretty surprising answers. So here's the setup. In one corner, you've got Marilyn Stevens, a homeowner absolutely convinced her condo association was breaking its own rules. And in the other corner, the Cliffs Condominium Association, basically saying her case had zero merit. This is the classic setup for a showdown over rules, power, and who's really in charge.
Okay, so our story really kicks off with Marilyn Stevens. And she wasn't just complaining to her neighbors over the fence. No, she took this to the next level. She filed a formal, official petition with the state, dragging her association into an administrative hearing. This was serious. So what was her beef, exactly? Well, her whole complaint really boiled down to two very specific things. First, she said the annual meeting they held back on January 10, 2004 was on the wrong date, a direct violation of the bylaws. And second, she argued that the election of board members for 3-year terms was totally illegal because the rules were never properly changed from 1-year terms. All right, let's dig into that first charge, the controversial meeting. Now, I know what you're thinking. A meeting date seems like a pretty small thing to sue over, right? But as you're about to see, when you're dealing with bylaws and legal challenges, the devil is always in the details. And here's the thing. Miss Stevens wasn't just going on a hunch. No way. She walked into this fight with what looked like a smoking gun. I mean, a piece of evidence that seemed so perfect, it felt like her case was a total slam dunk. And this is it. Get this. This is a direct quote from a sworn deposition given by the association's own president, a guy named John Caldemone. He flat out admitted that holding the meeting on that date violated the bylaws. An admission, under oath.
I mean, come on. With an admission like that, this should be over, right? The president himself said they messed up. What else is there to even talk about? Well, not so fast. This is where the story takes a wild turn.
Just when it looked like a clear, undeniable win for the homeowner, the association played its ace, a defense that came from a single, kinda hidden clause in the very same rulebook Ms. Stevens was using against them.
Now, to really get their argument, we need to quickly understand a legal concept called a waiver. All it really means is that you can lose your right to complain about something if you don't speak up at the right time. You basically waive your right to object. Keep that idea in your head.
This was the association's secret weapon. A little sentence buried deep in their bylaws that says any procedural mistake, like say, holding a meeting on the wrong date, is automatically forgiven or waived if nobody makes an official objection at the meeting itself.
So here's what it all boiled down to. The judge heard testimony that, yeah, some people objected to some things at the meeting, but the testimony was vague. No one could definitively prove that someone stood up during that meeting and made a specific, formal objection about the date. And because of that one fact, the judge ruled that the waiver clause kicked in. That slam-dunk admission from the president, suddenly it was worthless. Okay, so round one goes to the HOA, a major blow. But what about that second complaint? You know, the one about the board members being elected for 3-year terms, when according to Ms. Stevens, it should have been 1? This was still a huge point of conflict. This part of the case got pretty messy. It was basically a classic he said, she said situation. Ms. Stevens argued she never got a copy of any amendment changing the term lengths and that it wasn't even properly registered with the county. The association fired back saying, oh yes, the bylaws were amended way back in 2001 and we weren't required to register it anyway. It was just her word against theirs. And this leads us to another super important legal idea you have to understand, the burden of proof. In a case like this, it wasn't the association's job to prove they did everything right. The responsibility, the burden, was on Ms. Stevens to prove they did something wrong. So the standard she had to meet is called a preponderance of the evidence. That sounds all technical and fancy, but really, it just means she had to convince the judge that her side of the story was more likely true than not true. Think of it like tipping the scales of justice, even if it's just by a hair, like 51% to 49%. The scales had to tip, just slightly, in her favor. Okay, so all the evidence was in. All the arguments had been made.
The judge had heard absolutely everything about the meeting date, the waiver clause, the director terms, all of it. It was finally time to make a ruling.
So you can just picture the judge looking at all the pieces on the board. You've got the president's bombshell admission, but then you have that sneaky waiver clause. You have Ms. Stevens' claims about the director terms, but a lack of hard evidence to back them up. It all came down to this one moment.
And the final verdict? Petition dismissed. A complete and total loss for the homeowner.
So, what in the world happened? How did she lose so decisively? Let's recap the judge's reasoning. First, that whole complaint about the meeting date was thrown out because it was considered waived. Nobody made a clear, specific objection at the right time. And second, on the director terms issue, she just couldn't meet her burden of proof. She simply didn't have enough evidence to convince the judge the bylaws hadn't been properly changed years before.
You know, this whole case is way more than just a story about one person's fight with her condo board. There are some huge lessons in here for anyone who lives in a community governed by an HOA or a condo association. So what are the big takeaways from all this?
Okay, first and most important, the fine print is everything. A tiny overlooked clause, just like that waiver rule, can completely flip a case on its head. Second, procedure is king. If you have an objection, you absolutely have to make it at the right time and in the right way, or legally, it's like it never even happened. And finally, the burden of proof is real. It's not enough to be right or to feel like you're right. You have to be able to prove it with solid evidence. It really makes you wonder, doesn't it? In these communities, who really holds all the cards? The people who are in the right or the people who simply know the rule book best?